Today we are going to review the 10 things that you need to know before you hire a workplace investigator. My name is Dorian Prasad and I am the senior lawyer at Prasad Employment Law. We are a team of lawyers who specialize in conducting workplace investigations, and we help you to create healthy workplaces by completing investigations that will stand up to scrutiny, by providing you with the training that you need, and as well as proactive advice. We have reserved about 20 minutes this morning to review the slides in terms of the 10 things that you need to know before you hire an investigator. We're going to spend that time going through the material, and then we've reserved a lot of time on the back end to answer your questions. I would encourage you to use the Q&A function to pose your questions to us. You can find that if you click on the chat link, and within there you'll see the Q&A function. Please do send us your questions at any time throughout the presentation, and as I said, we'll deal with each of them in turn at the end of the presentation. If for whatever reason we aren't able to get to your question, please be assured that I'll connect with you afterwards to make sure that you get the answers that you are looking for today. Also, you will all receive a copy of the slides for this presentation after the event. I was speaking with an HR manager recently. She had just received a complaint of sexual harassment and sexual assault. And the complaint came from two individuals. One individual had experienced these behaviors recently. The other employee came forward because she wanted to support her colleague. She had allegedly experienced the same or similar behaviors 2 years ago at the hands of the same responding parties, and she wanted to be there to let her story be made known and to support her colleague. During the course of the employees telling their story, they also mentioned that 2 years ago, this employee, we'll call her complainant one, she mentioned that she tried bringing the issue forward to her manager at the time, but that person essentially dismissed the complaint and said, welcome to the club. That happens to a lot of women here. You can imagine the HR manager was very troubled by what she was learning for the first time. And we can all agree that when presented with these facts, it's without question that an investigation has to be conducted. There is if the allegations are true, there's a violation of policy. There are certainly violations of the employee's statutory rights. And as the employer, it's your obligation to create and to maintain a workplace that's free of violence and harassment. So to that extent, the fact of conducting the investigation is very clear. However, what's going to be the scope of that investigation, right? So the first thing that you have to keep in mind before you hire the investigator is, what is going to be that person's mandate? What are you hiring that person to do? And that is extremely important in terms of providing clarity to the investigator, but also important in terms of for yourself in terms of managing the investigation and keeping things on track. So in the scenario that we just outlined, the manager here, she had a choice. She could keep the investigation focused narrowly on just the more recent complaint that had come forward. She could expand the investigation to look at the complaint that was brought to her attention that allegedly occurred 2 years prior. Or she could say, look, just based on what has been presented, maybe we need a systemic review. Are there systemic issues here that need to be addressed? We need to get a handle on the scope of that issue. and the health of our workplace. And so a broader or a systemic review would be necessary. So these are the things that you want to think about, that you want to connect with legal counsel on to determine what's the best approach in a given circumstance. The second factor that you want to consider before you bring on an investigator is, what's relevant. You have the allegations. Are those in written form? Do you have a sense as to the full scope of what is alleged to have occurred? So certainly the allegations and how thorough and well known they are is going to be important. Do you have policies and procedures that address the conduct in question? I think many organizations have policies in place, but maybe they haven't been looked at in a while. Maybe they don't exactly capture the behaviors in question. But certainly, you'll want to get your hands on those documents, because they'll be important for the investigator as that person does their work. And then finally, our experience is that many of these cases, whether it's arriving at a conclusion on an allegation, or if it comes down to a credibility assessment, the emails and text messages that are exchanged end up being very critical evidence. So to what extent, do you have tech support that will be able to assist and to help you and the investigator access critical information to either underpin whether or not something happened, or determine credibility as you weigh the evidence between two witnesses. A third fact that you want to consider is who's involved. Right? You have the affected parties in the scenario that we reviewed. You also have the manager who allegedly 2 years ago was dismissive of this very serious allegations. There are going to be other witnesses that may be involved, and so you want to get a sense in terms of how many parties are involved, how many potential witnesses there are. And that's important, not only just in understanding the scope of the investigation and the investigator's mandate, but it's also important in terms of identifying, look, is this something that we could take on in-house, or do we need a third-party investigator for this? There are so many cases where organizations ignore, the personal relationships that are involved, and they investigate a complaint without, really paying enough attention to that fact. One example that comes to mind is the, seminal case of Bell Mobility and Pires Ferreira, and that's a case involving an individual who was having issues with her manager. She alleged verbal abuse and harassment over a period of time. She was allegedly shoved. She fell into a filing cabinet, and she never returned to work. Bell Mobility, in reviewing and investigating that complaint, had an HR manager do that work. And it turns out that the HR manager was friendly with the responding party involved. They had essentially, grown up within the Bell Mobility organization. They socialized outside of work. And so while they weren't necessarily close friends, they were certainly friendly. And the court pointed out that, in a workplace investigation, there are serious rights at play. There are consequences for one's actions. And it's important that organizations do that work, and that they do their best to get it right. And part of getting it right is putting in place a process that is free of bias, or at least, and also that includes, being free of even the appearance of bias. So in this case, where you have a large organization with a lot of resources situated in a large center, there is certainly no reason why Bell Mobility couldn't have selected someone, again, who didn't have that personal relationship with either of the parties, or simply just gone external and retained an external investigator for that matter. So again, looking at the personal relationships, I have lived and worked in a smaller city before, and my experience there was, everyone is connected. You're only 2 or 3 steps removed from many people in the community. So that being the case, I would say, especially if you're in a smaller organization or working in a smaller center, you definitely want to be cognizant of the relationships and be honest as far as whether or not you could, conduct a rigorous investigation if you were doing that work in-house, or whether it would then be best to use an external investigator. And even then, do you use an external investigator from the community, or do you go and look more broadly? So those are some key considerations that you'll want to be mindful of when these allegations come across your desk. The fourth factor that we're going to look at are, what are the risks to the organization? What are the potential risks? What are the probable or the likely risks? I conducted an investigation for a school board last year. It involved allegations of racial discrimination. The students who brought the allegations forward were using a third-party, I'll call it advocacy group. And this advocacy group seemed to me, they were out for their pound of flesh. They just wanted to see folks disciplined or lose their jobs over the alleged misconduct here. And they were threatening all kinds of action and threatening to take the story and approach newspapers and to make things public, all without a proper investigation having been done. So the school board was wise to say, look, in the circumstance, given the nature of the allegations and just given how inflammatory this group, the way that they're behaving and the way that they're speaking and conducting their business, we need to have someone experienced come in to best deal with the situation. So those are the things that you want to be mindful of. Is what is the risk here? Maybe even if you don't see liability because you know that you've done all the right things, is someone going to smear your reputation and or your employee's reputation again because they deem that there's an injustice that's occurred? And that brings us to the fifth factor in terms of who should be selected. Some of the key considerations that you want to keep in mind here is experience. And that includes not just experience conducting investigations, but experience in the specific situation that you happen to be faced with. We covered a case for you, Elgert and Home Hardware, where there was an allegation of sexual harassment, and Home Hardware appointed an internal investigator to that case who had very little experience conducting harassment investigations and had actually never conducted an investigation into allegations of sexual harassment. So this person was completely unprepared for how to approach the parties, how to approach witnesses, how to set up this investigation, and not surprisingly botched the investigation, and which resulted in increased liability for the organization. So you want to make sure that the person that you're looking into has the right experience. Also, litigation experience matters. The situation that you deal with very likely is going to, or could very likely end up at litigation. You discipline or dismiss a teacher or a professor. These are sophisticated actors represented by powerful unions. They are going to grieve that action, and you're going to have to defend your case likely at arbitration. You want to make sure that the investigator has explored all the different options, that they understand how they're going to be cross-examined and how others are going to be cross-examined at litigation. They want to make sure that they've covered off those avenues during the course of conducting their investigation, so that when you get to the arbitration, the whole case doesn't fall apart. This very important decision, this consequence about someone's continued employment, rests on the conclusions of the investigation report. And if that report falls apart at arbitration, well, now the individual is entitled potentially to reinstatement and back pay. So having that litigation experience, knowing how to put together a case, is very important. Related to that is also being able to handle conflict, right? Because I go back to that example of the school board dealing with this third-party advocacy group, and they're just out for their pound of flesh. They're not interested in the truth. They just want to be confrontational and be aggressive and make sure that folks, pay the price, as they, the advocacy group deem fit. So you are going to get a lot of pushback, setting up the investigation. You're going to get a lot of pushback conducting interviews. You have to embrace the conflict. You need someone in there who has been through the fire before and who's not going to shirk away from the difficult moments. So it's important then, especially when you are dealing with contentious issues, that you're not just dealing with someone who is approaching this from an academic perspective, and you need someone who's been involved in conflict and litigation, and they know how to handle themselves in that context, and will be firm, but still do the work in a neutral and impartial way. And that's ultimately going to serve you better in terms of making the investment in the investigation. That brings us to communication. And communication is such an important aspect when it comes to investigations. And there's two aspects to this. You've got communication between you, the employer, and the investigator. And then you've got the communication between the organization or the investigator and the parties. So let's deal with the first one, the communications between the investigator and the employer. One of the frustrations that we often hear is the employer is, in the dark. They bring in the investigator, things start out right, but time's dragged on. It's been several months. They don't know if they are close to the end or if they're in the middle, and they really feel lost in terms of where they stand in the process and how quickly is this going to wrap up. We've implemented a practice at our firm to provide weekly updates to our clients. So that way, as the employer, you always know what's happening with the investigation each week. So whether interviews are scheduled, whether the investigator is or is not getting cooperation from certain parties, you're always in the know when it comes to the stage that the investigation is at, and that's important. So you'll want to make sure that you turn your mind towards to what works for you. If maybe weekly is too often, maybe bi-weekly works better, but you want regular check-ins, and that helps you, both to know what's happening with the investigation, but also to better manage that external investigator. When I first started conducting investigations, and that's going back about 20 years now, it used to be the case that you really only connect with the parties at certain points in time, and mainly that's leading up to an interview. So you conduct that interview, and then after going through the process, maybe there's the need for a follow-up interview. So you would connect with one or both of the parties at that follow-up interview, and really then there's silence until you submit your conclusions to the employer. We've tweaked that a little bit. Our sense of it was that it's difficult for both parties, the complainant and the responding party, to sit there, really uncertain as to what the future holds for them. And so we try to provide regular updates to the parties as well. And it doesn't have to be a weekly update, but just depending on how long the investigation is going to take, you want to just check in at reasonable intervals of time and let them know, hey, look, we've completed our interviews, and maybe within a couple of weeks we anticipate rendering our conclusions. Whatever the case might be, there's a judgment call here, depending on the size of the investigation and how long it's going to take. But just letting the parties know, generally what stage it's at, we find to be a helpful practice, and helps folks to get through that in better shape. Another factor that we wanted to review with you is process and preparation, and so these are questions that you want to ask of the investigator that you're contemplating, especially where you're looking at bringing in an external party. And what's their approach to investigations? Do they have a general process that they follow? I was surprised to learn that there are some firms out there who are using multiple investigators for a matter, based on the availability of investigators within their firm. So you might have one individual who interviews the complainant, and again, because of availability and caseload, they might have somebody else who interviews a witness, and then somebody else who interviews the responding party, and then the person who's tasked with pulling together the investigation report and making conclusions, that person hasn't sat with all of these parties and witnesses. They haven't heard the evidence firsthand, and that makes it very difficult for them to do the job well. It's certainly best practices for one person to have carriage of the file and to take the lead in terms of those interviews, and you might have a colleague with you, but certainly there's one person who you can rely on to be involved in all of those investigation interviews. So if it's your expectation that that's happening, then you want to make sure that that's clarified with the investigator or with the firm that you're speaking to make sure that those expectations are met, because as I said, there are folks who are doing it differently. Related to that is having a contingency plan. Certainly investigators can have events happen in their life too, which disrupt the investigation, whether that's through illness or death in the family. And so it's helpful to have that top of mind and part of your conversations to find out, hey, look, is there somebody else who on the team that's able to step in if there are circumstances that lead to the investigator having to take some time away before concluding the investigation. As we know, confidentiality is extremely important when conducting an investigation. And I want to go back to the story that I told about dealing with the school board and this third-party advocacy group. I had, prior to my meetings with one of the students, one of the complainants on that matter, I provided her and her mother and this representative with a confidentiality statement that I wanted them to sign, and it was the standard terms that they are going to be candid with me during our interview, and that they weren't going to discuss those issues that we were covering during our interview outside the confines of the investigation. And they flat out refused to sign the agreement. They were actually offended that I had presented them with this document in the court. So I had to switch gears and try to understand where they were coming from. Ultimately, what I decided in that case was, well, we're not going to do virtual interviews. I'll travel out to the community and we'll do interviews in person. And I made sure that they checked their cell phones. And electronic devices at the door. I later found out that they had plans to live stream their interview with me. So they had actually done this before, not sorry in the context of an investigation, but they had recorded their conversations with other members of the administration, and they thought it was completely appropriate for them to record this interview and broadcast it to their members and stakeholders. So you honestly just never know what other people's understandings are when it comes to confidentiality. I think certainly when you're looking at a traditional office context, right, there's some common ground there and a common understanding that, yes, these things do need to be kept in confidence, and there's a mutual respect, and that's generally adhered to. But there are other contexts, as I mentioned, where you're dealing with folks who don't have that level of professionalism and are going about their business in a different way. So you definitely want to make sure that those expectations that you have are made clear with the investigator, and that you understand what steps the investigator is then going to take to enforce those expectations with the parties and witnesses that are involved. The next factor is timeline, right? Every investigation has different stages. You can generally break it up into the setting up of the investigation, and then you've got the interview stage, and then you've got the report writing stage. And with most issues, there's a sense of urgency, right? Some cases more than others, but usually, when one of these cases comes across your desk, you want it wrapped up in a short period of time. So you want to canvass that with the investigator and find out what their availability is like. And by availability, it's not just can they start the investigation next week. Sure, they might have a couple hours available to jump into an interview, but what's their availability to complete the investigation? Can they complete those stages that we mentioned? Do they have that availability themselves, or are they relying on other members of their team? You want to find out what their sense is, given the information that you disclosed and the scope of the investigation. What's a reasonable timeline here to get these done? At our firm, we make a commitment to complete the investigation in 30 days, and we do that at a fixed fee to provide certainty to our clients. So that's our commitment. Again, you need to speak, with the with firms and find out, how they see the case and what it is that they're able to commit to, especially if, as I said, you have a specific timeline involved. And then finally, the report. The report brings everything together, right? All of the interviews with the parties and the witnesses, all of the emails and text messages that have been examined. Everything gets distilled and pulled together in some way. And so what you want to turn your mind to early in the process is, what sort of report do you think is best? For the HR manager that I referenced at the outset of the presentation today, because of the likelihood of the case that she was facing, ending up in front of the Ontario Human Rights Tribunal, or maybe becoming part of a constructive dismissal lawsuit, tied up with human rights damages. Because of that risk of litigation, she was in need of a robust report that pulled together all of the evidence and with its conclusions. The audience that she had in mind was ultimately, this report is going to be produced in the course of litigation. Opposing counsel will see it. The audience for her was really the judge, right? In your case, it might be a judge or an arbitrator, but that's what you want to keep in mind is ultimately, based on the facts that you're dealing with and the risks that are attached to the investigation, what's the product that you need at the end? And in many cases, a summary report is fine that outlines the process that was followed and who you met with and the conclusions, the allegations that were made and the conclusions for those allegations. And that summary report will serve you just fine if somebody, maybe a regulatory body, after the fact says, hey, we have a complaint from a former employee, and she says that she filed a harassment or discrimination complaint and you never looked into it. You want to have a summary report available to say, well, that's not true. Here's a copy of the report. Here's what was done. And so that report, for you, helps you to, paper the file and move on to the next matter on your desk. So those are the 10 things that you want to consider and turn your mind to before you bring on a third-party investigator. It will help you to inform your discussions with that third party. It'll also help you as you complete a retainer agreement and spell out the expectations and the deliverables when it comes to the investigation. So with that, we'll move to our Q&A session. And again, for those of you who haven't as yet, please do use the Q&A function to pose your questions. And my executive assistant, Neha, is on the panel with me this morning and is going to help funnel those, feed those questions to me. Any questions, Neha, that have come forward as yet?
At the moment, no.
Okay. Okay.
Yeah, no questions. Oh, I see one question come in.
Okay.
Okay, here's a question. Have you seen any cases where the outcome of the investigation was impacted by who conducted the investigation, whether internal or external? When is it best to get an external investigator right from the beginning?
That's a great question. So one of the things that you want to look at is, I'll go back to that, is impartiality. And I'll go back to the case of Bell Mobility and Pires Ferreira. That was a case where you had a manager who's accused of serious misconduct, the harassment and ultimately the physical act of shoving his subordinate. And Bell Mobility went with an in-house person who was friendly with the responding party. And what the court said there is that at the very least you want to make sure that there isn't any bias, but you want to ultimately put in place a process where there isn't even the appearance of bias. So you want to look at the relationships, and are you able to hold this individual accountable? You want to look at the status of that individual as well, right? Think about appointing an internal investigator, and the person who's accused of misconduct is a senior vice president. How comfortable is that HR person going to be sitting across the table from an individual who is so much higher up in the hierarchy of that organization, and really be able to pin that individual down and ask the difficult questions that are required in the circumstances? So you want to look at that power imbalance, right? That might exist, and so who's involved is important. And then you want to look at the risk of litigation. I go back to that example of a school board and the advocacy group that is threatening litigation and threatening to go to the press. Well, they've already alleged that you're biased, even if you aren't. They've alleged that you're covering up racial discrimination, which you may not be. But in order to, you want to put together a process that's going to stand up to scrutiny. You want to put together a process that the community, right, can rely on at the end of the day. And so in that circumstance, it was a wise choice to bring in an external investigator, and we were able to diffuse some of that conflict, right, between the group and the board, and kind of stand in the gap, so to speak, and then get at the truth of what happened. So those are some of the key considerations when it comes to should you go in-house or not. Some of the other considerations would be the time involved, right? Like these investigations are very time consuming. I remember one of the first ones I did, the organization got a complaint 2 weeks before Christmas, and they wanted to complete it before Christmas so they could make a decision going into the holiday season. And that required me working basically for around the clock for the better part of a week to get that done. So oftentimes you don't have the resources internally to dedicate folks to drop what they're doing and respond to an investigation. And then I would say the final part of it is cost, and you want to look at what is the external investigation going to cost? What are the internal resources going to be? Again, there's a cost to that as well, right? Pulling people off of important projects and throwing them onto an investigation. So you want to weigh those things and then decide what makes best and what would be best for the organization in the circumstances.
That was great. Thank you, Dorian. We've got another question. How might cultural differences inform the way the investigator can best approach explaining the concept of confidentiality?
That's a great question, and think as especially as a lawyer, we come from a place where we live in this world of confidentiality, and is just second nature, right? It's just part of what we do, and informs so much of our interactions. And you really have to take off that legal hat, and in the case I referenced with the school board, you have to sit down with the student and really, I think, understand what their objectives are and what their concerns are with confidentiality. Because this, you look at the power imbalance or the perceived power imbalance there. The students, their sense of it is that they're coming forward and they are the little guy, and they've made these serious allegations, and signing this confidentiality statement tie their hands in any way from pursuing maybe a non-traditional route to getting a resolution. So instead of going through arbitration or going through the court system, is there can they put public pressure on the board to take action? So it's understanding their strategies and what their goals are, and sometimes those things are aligned and sometimes they aren't, right? So I think it's sitting down and better understanding that perspective, and then trying to work with them to respect the investigation, understand that is a mechanism to them ultimately satisfying their goal of understanding what happened in a particular circumstance, and then coming out of that, they may not be happy with the outcome of the investigation or the conclusions, but you're asking them to invest and cooperate with a process that is meant to gain trust, and you're using a trustworthy person, using an expert to do that work, and so you're trying to come alongside them to some degree to get them on board.
Thank you. We've got another question. When an organization has an internal investigations department, what circumstances may require an external investigator?
When you have an internal investigation department, you have folks who are well versed in doing investigations. Sometimes you come up against I'll call it a frequent flyer, right? Someone that you've investigated before, and that person comes forward with a new complaint. They may have concerns in terms of, are they being treated fairly by this in-house department? Are they going to get a fair shake because this person or this department investigated their concerns before, maybe didn't find in their favor, and again, like how robust or how good a job is this department going to do this time around? That maybe there is some. Maybe there's more to the story than that, right? Maybe in the other case, in the other complaint again that the employee filed, maybe that went through the grievance process to some degree, right? So now it's not just that that this department has investigated a complaint, but they've investigated a complaint. They've also participated in a legal process, and likely, there's some acrimony there. So again, does that, result in either, actual bias or perceived bias going forward? And that's important, right? You want to make sure that those issues aren't at play, that the employees in the organization can have confidence, right? That the work's going to be done well, that's going to be done in an impartial manner, and that they can rely on that result. Because if they have that confidence and if they have that trust, then you could potentially avoid a legal process. But where you don't have that trust, then no matter what you come up with, you're going to end up in a legal process, because they're going to want access to the report. They'll want access to all of the evidence behind the report. They'll want access to the what evidence did you collect that was not included in the report, right? It just becomes, how do we attack this investigator and these conclusions? So I think the labor relations environment plays into this as well.
Thank you, Dorian. Our next question is, are there any resources that show what should be in an investigation report, either to guide our internal investigators or to evaluate our external partners?
Sure. If you send me, and that's a great question, if you send me an email, I can give you a template of a draft investigation report, and that will show you, the various sections that should be in there. We'll obviously send you an anonymized report, but at least it'll give you a sense as to what the report should cover and in what detail. And then happy to connect with you afterwards if you're looking for any resources beyond that.
And we have another question here. What tips do you have for the internal team to apply upon receipt of a complaint prior to determining whether internal versus external is the best approach? How in-depth should the initial review of the document collection be?
So you need to do some vetting when you receive a complaint, right? You want to connect with the complainant and find out, have they shared their whole story? Is there more to the story here? So certainly connecting with the complainant to make sure that you have a handle on what their allegations are, and maybe how the timelines involved, right, over what period of time these allegations span. That's going to be helpful. In terms of the document review, it's rare that you need to get knee deep into a document review. What you want is for the individual to know that their complaint is going to be heard, that's going to be investigated, internally or externally, but there will be a fact finding that's done, and that the investigator is going to be asking them for all relevant information. So that includes, right, the emails and text messages and whatnot, any notes, right, that the person may have taken. So you want to let them know that those things exist. But I think for the purpose of vetting the complaint, it's really just a matter of, I think, speaking with the individual and just making sure that you have a good sense as far as the allegations and who's involved, and that will give you, generally speaking, of course, that will give you enough information to know, do these allegations trigger an investigation, right? Like, is there if the allegations are true, does this violate a workplace policy? Does it violate this statutory obligations? And then to the extent that it does trigger an investigation, or there is even apart from that, there's potential reputational risk. The decision's made to conduct the investigation, and then from there, I think you could probably rely on the investigator to do more of that digging in terms of pulling relevant information together.
Thank you for that. Another question. What advice do you have for HR and department supervisors when investigating employees or determining an appropriate investigation in a union environment, specifically a group who advocate loudly for the employees?
So Neha, is the question best practices for dealing with investigations or complaints that where you're required to investigate
Yes.
within this group?
Yes.
So in terms of the best practices, I would say you don't need to change your process for different groups, but you need to be mindful of the risks that are posed. And so I do appreciate the attendee posing the question. Mentioned that this tends to be a vocal group. So you just want to know that that this is one of those higher risk investigations that that they're likely to grieve to some extent, whatever the outcome is, but they don't get special treatment. And one of the things that that I will say is that sometimes folks feel emboldened, right, because of what they've been allowed to get away with up until a certain point of time, and then when you start doing investigations or maybe bringing in third parties to do investigations, that changes the tone and people get their backs up. I remember doing one for a school board a few years back, and this the union rep for assisting the employee, she wanted to she wanted to have a conference in the middle of my interview. And I just thought I wouldn't allow it. I was like, no, you're not going to have a conference in the middle of this interview. We're doing a key line of questioning. I'll give you time to connect with the witness in 10 minutes, but she has to answer the question right now. And I insisted on it, and they weren't happy about that, and they raised it with the HR manager afterwards, and it's like, you wouldn't believe what Dorian did. You wouldn't let us conference. And I was unapologetic because they've gotten away with it in the past, where they essentially abuse the investigation system. They treat it like it's collective bargaining, and you can just take breaks whenever you want. But it isn't. It's more closely akin to a cross-examination in open court. You can't put your hand up and say to the judge, excuse me right now, I need to have recess. The judge is going to say, well, I appreciate the request, but the witness needs to answer the question. And that's the same scenario that you're dealing with in an investigation context. So the best practice, I can say, and I'm happy to have a one-on-one conversation to better understand the particulars here, but you want to make sure that you have a process that you follow, and you want to make sure that when you're dealing with contentious individuals, that you have the right person sitting in the investigator seat to ask those questions. So you're not doing anything differently. You're following your process. You're getting at the truth. You might ruffle some feathers in doing that, but you're not doing it in an unfair way. And then you arrive at your conclusions, and then you take the steps that you usually would. And so the fact that they might be louder doesn't give them any more leverage over the process that you employ, if that makes sense.
Thank you, Dorian. At this point, we don't have any more questions.
Okay. Well, thank you, Neha, for fielding those questions. I want to thank you all for attending the webinar today. It was a pleasure spending this time with you. Your questions were extremely insightful, and we hope that we were able to provide you with some guidance and some insight into your situations. So please don't hesitate. As I said, if your question wasn't answered or you're looking for a one-on-one to maybe cover a topic in depth, happy to have a virtual coffee with you, and we can unpack that situation. We will be running these webinars monthly. Our next one is scheduled for the end of October. So please look out for that invitation. And if you found the webinar helpful today, we appreciate your feedback. Please let us know if it was helpful to you, and please do share the word so that we can share these resources with as many folks as possible. Thanks again for being here today, and we look forward to seeing you again soon. Take care.